Good evening, ladies and gentlemen. In tonight's presentation, we will discuss the topic of whether online game webcasting by streamers constitute fair use. This is the outline of a presentation, a sequence of speeches. In the first part, I will introduce the development of China's online webcasting industry and whether streamers can claim any copyright in the webcast picture as authors. In part two, Wu Tianxiong will present relevant legislations and policies on fair use in China. In part three, Han Qi will discuss in details the three-step test adopted by the Chinese courts for determining fair use. Now Wesley will discuss the four-step test in the US in part four. In part five, Xie Nanyi will illustrate with a concrete leading case in China, that is NetEase and Huaduo. Finally, Wang Rouwen will draw a comparison between the three-step test and the four-step test and conclude in the context of Chinese copyright law. By way of introduction, the online game webcasting industry in China experienced generally four stages. Before 2013, it is emerging period. Voice chat tools such as YY and video sites such as ACFun started entering the field of live webcasting as platforms. From 2013 to 2014, platforms' live streaming systems operated independently, and we can see Huya and Douyu went independent from YY and ACFun respectively during that period. From 2015 to 2017, it was the explosion period. With huge capital injection into the market, numerous streaming websites sprang up to fight for the market. From 2018 to now, the situation stabilizes. After fierce competitions, the market ended up with a duopoly by Huya and Douyu. Both completed initial public offerings, and the great majority of competitors got eliminated, including the famous Panda TV. Because of the lucrative business of webcasting, disputes on copyrights and lawsuits for infringement have also seen a sharp increase. So before we move on to our principal discussion, it is necessary to analyze whether streamers can claim any copyright as authors in the first place. While the level of contribution of streamers can be considered by courts, under normal circumstances, it is difficult to support streamers' claim to the copyright to the webcasting of games as authors. First of all, the operation of streamers cannot meet the originality standards required by the copyright law. Such operation subjectively lacks creative intentions, and objectively, it may simply repeat various game materials pre-incorporated by developers. The only exception is that streamers use the pre-incorporated materials of the game to create a brand new work that is different from the original audiovisual content of the game. Only in these very rare circumstances, the streamers could constitute authors of derivative works. Secondly, streamers usually have disposed of their substantive rights generated by the online game through user agreements, which can be regarded as the player waiving their copyrights and other rights enjoyed as the author of the webcast picture. Thirdly, it is arguable that streamers play the game for the purpose of copyright. Instead of positioning themselves as authors, players are game participants attempting to get joy and popularity by playing. Fourthly, compared to online game developers, the cost paid by developers for online games is extremely low. If the player enjoys the copyrights of the online game live picture work and can prohibit online game developers from using the picture, it will undermine the equality, fairness, and reasonableness rights and obligations between online game developers and players, which is incompatible with the principle of balance of interest under the IP law. As generally streamers are unable to claim copyright as authors, my colleagues will discuss in details whether they could protect themselves from infringement on the basis of fair use.
I'm sorry that the camera in my computer was broken, so I'm afraid that you guys can't see my face during the presentation, but I think that's not a big deal. Well, let's begin. First of all, video games will be protected by copyright law only when they can be classified in the catalog of works. At present, video games is hard to protect by suitable types of work. Article 3 of Chinese copyright law adopts the exhaustive list of operation the type of war, and video games are not one of type of war stipulated by it. Video games are obviously computer software, but only with the protection of computer software alone is not enough to protect the benefit of video games. The benefit of protecting a video games is to attract players with the content 8% rather than how the software is programmed. Some people think that the game as a whole can be seen as compilation work, but the combination work mainly protect the originality of the combination and cannot provide sufficient protection. Movie-like work can provide more comprehensive protection, but still being questioned. It can be said that the difficulties faced by the games mainly stem from the strict classification of work in Chinese copyright law. According to Article 22 of Chinese copyright law, game webcasting does not belong to 12 types of fair use situations stipulated in the Chinese copyright law. If only explained based on current IP law, game webcasting does not belong to the fair use. However, although China currently adopts exhaustive list model in relevant judicial practice, the court has broke through the exhaustive list and judged certain acts that were not originality used as fair use. Article 33 of the Draft Review of the Copyright Law of China had added other circumstances for fair use, looking forward to changing the list model. This means in practice, the game webcasting may be considered as fair use. However, fair use still needs to meet certain conditions. Article 21 of Chinese Implementation Regulation on Copyright stipulates that fair use must not affect the normal use of work and must not unreasonably harm the interest of the copyright owner. Once the normal use of the work is effected, it cannot be considered as fair use. But what is normal use should be defined. The expert believe that normal can be interpreted as routine, often, typical, usual, and traditional. There are two different understandings to interpret normal use in practice. From a stricter perspective, the value normally obtained by a game can be include the market value of the game itself, excluding the game webcasting market. China copyright lawmakers believe that the new method of spreading wars, such as webcasting, and which have been introduced with the internet technology, have harmed the right of the copyright owner and affect the incentive of author. Therefore, the lawmakers tend to protect the copyright owner. However, according to the classic principle of the law, the methodology proportion principle beside protecting the copyright owner or the author, it is necessary to balance the interest of the copyright owner, the user of the work, and the public information demand. Therefore, the legislative progress, it is necessary to examine whether the purpose and the means in stay with the proportion and whether there are other alternative means that cause less damage to the right holder. From the perspective of jurisdiction, the cost of Chinese implement regulation of copyright refers to the last two steps of the three-step text of the Berne Convention. The detail and the logic of Berne Convention will be elaborated by my teammate in part 3. Thank you.
Now in this part, we will introduce three-step test in China. The three-step test first appeared in the Berne Convention in the Stockholm text of 1968. The basis for the dissemination of works is the right of reproduction. At this meeting, the expert committee decided to set a general and abstract standard for limitations and exceptions. Under this background, the three-step test emerged. Here are the provisions about three-step test in Berne Convention and TRIPS Agreement. The TRIPS Agreement inherits the Berne Convention and introduced three-step test. it is not difficult to find that the TRIPS agreement extends the rights of reproduction to exclusive rights and extends the legitimate interest of the author to that of the right holder. The three-step test starts from the Berne Convention and develops in the TRIPS agreement. Later, WCT and WPPT all take the two conventions as a model, so it becomes the most widely used and widely applicable fair use judgment standard in the world. China has acceded to the Berne Convention, TRIPS agreement, and other treaties listed on the left side. All of these treaties have explicit provisions on the three-step test. Here are the provisions about it in the WCT. Although the three-step test have some differences in the text of the various treaties, the first step, confined limitations or exceptions in certain special cases, have always been regarded as a general rule in Germany, France, the Netherlands, and other civil law countries. This general rule guarantees the stability, operability, and the predictability of copyright limitations and exceptions, which can neither be ignored nor overridden. Therefore, the civil law countries usually stipulate the limitations and exceptions by enumerating in an exhaustive way. In the first step, certain should be understood as reasonably foreseeable circumstances, and special should be understood as for particular purpose. For the special purposes, including promoting research, education, and cultural communication, supporting specific industries, caring for specific vulnerable groups, and so on. Reasonably foreseeable stresses not to make a surprise attack on the copyright owner. Therefore, the former protects the user's interests, and the latter protects the interests of the obligee. The former focuses on the public interests, and the latter focuses on private interests. However, the first step is not a threshold to the second and the third step. In other words, even if it fails the first step test, we can still investigate and apply the second and the third step and integrate all these factors into the overall balance. Second, fair use shall not conflict with the normal use of the work. The provision of this article is merely to protect the priority of copyright owner. For competitive games, the audience can learn the operation skills and improve their level of playing the game by watching the webcasting, which will not produce a substitute impact on the game itself, and even stimulate audiences' desire to play the game. In this case, normal use of the work will not be affected, but for story-oriented games, webcasting may cause users to lose their curiosity and interest, so we should analyze case by case according to the type of the game. Third, do not unreasonably prejudice the legitimate interests of the right holder. For example, in the case of Yaoyu versus Douyu, Douyu broadcast the game without any permission. This kind of behavior will cause loss of audiences and other adverse effects on the interests of the game organizer, so it is not fair use. China and Germany have different ways for interpretation. Unlike German courts, which fail to break through the closure of limitations and exceptions, the Chinese courts tend to expand the interpretation of certain special cases, breaking through the closure enumeration and replace decided by the law with decided by the court. In order to explain the second and the third step, Chinese courts use the four-step test in US as reference, which may be a judicial innovation to combine the two imported rules.
In the fourth part, the four-step test, in the US, it adopted a flexible copyright exemption regime. The four-factor assessment approach of the US is arguably better suited than the approach of accommodating new technology, viewed as an effective measure to keep up with the rapid technological advances. As an Affirmative defense and alleged infringer of video game copyright may argue the public gameplay is protected under the fair use doctrine. The fair use doctrine grants exemption from copyright infringement to certain category of use. The preamble of the fair use statute establishes 6 different uses which fair use exemption may apply. However, the list is not exclusive. Although playing video games does not fit neatly into one of the categories, the use simply needs to be framed within 4 factors to satisfy the spirit of the copyright law. For the first factor, the purpose and the character of the use, related to 2 words: productive use and commerciality. The Universal Studio case is the first case to recognize the productive use, and later on the Supreme Court in the Campbell case determined how to constitute whether the work is transformative. And later on, 2 recent case from the Ninth Circuit decision has enhances how to qualify transformative use. And in Sony computer cases, afforded opportunities for gameplay in new environments, and more importantly, was whether a wholly new product. And in the Kelly cases, show that a use that serves different functions can indicate adequate transformation. In commerciality, the statutory language suggests that the commercial nature of use weighs against a finding of fair use. Although the commercial use of another copyright material is presumed unfair, this presumption is not absolute and can be rebutted by the other characteristic of the commercial use. The case in Campbell illustrates the commerciality factor may become less important if a strong indication of transformativeness is found. Therefore, being non-commercial in purpose and character is not necessary condition for finding the fair use. And there are a few cases showing that in support the rationale. In other words, the definition of commerciality in the context of the fair use factor is quite broad because the touchstone of the profit or non-profit distinction is not whether the sole motive of the use is momentary gain, but whether the users stand to profit from exploitation of the copyright material. Accordingly, even if the public gaming event is not strictly for profit, the use would be deemed commercial as long as the event organizers stand to profit from the overall enterprise. The second one is the nature of the copyright work. The second factor presumes some works are closer to core intended copyright protection than others. In general, a creative, fictional, and fantastical work is according greater protection than a factual, informational, or functional work. More specifically, if a copyright work is more appropriately categorized as entertainment, then it is less likely that a fair use will be fine. So the third factor is the amount and substantiality of the proportional use. This inquiry concerns both qualitative and quantitative substance as a general matter. The larger the volume of the greater the importance of the use, the less likely that taking will qualify as a fair use. Through reproducing the entire work, which typically bars the fair use defense. A use may still be fair when copied in its entirety. On the other hand, even if a small amount of the use have been found excessive when the proportion being used was deemed to be heart of the work. So how to define the heart of the work? There are two ways to do so. However, the first one is considerably less clear-cut, and the second one is more suitable to determine the heart of the work. Last but not least, the effect of the market harm is the most important factor, is the effect the use upon the potential market of or value the copyright work. In the Dr. Seuss case, it highlights this factor seeks to strike the delicate balance between the benefit the public will derive if the use is permitted and the personal gain the copyright owner will receive if the use is denied it. In the market harm analysis is the degree of potential market substitution that may take place as a result of an envisioned use. The more transformative a use is, the less substantial the result market substitution will presumably be.
Hi everyone, next I will analyze the NetEase vs. Huado case from a new perspective, hoping to provide more thinking directions. Remember, the question is online game webcasting a type of fair use? First, a quick review of the judgment that argument of fair use is groundless for two reasons. Firstly, webcasting falls out of the scope of Article 22. Secondly, under the US model test, Huado's use of game screen is for commercial purpose. The amount and substantiality of the portion webcasted exceed reasonable limits. The game screen is copyrighted, and the webcasting will affect adversely on the potential markets of NetEase. It is noted that the court supported the webcasting interest should be internalized into licensing interest through the expansion of the game screen copyright. In this case, as in other previous cases, judgments reach conclusions by interpreting legal provisions. But this case involves the distribution of interest in a new emerging industry and the construction of its rules. So we should also discuss this question in the context of industrial interests. The key problem underlying fair use in game webcasting is whether the copyright in game screen should be expanded to the field of game webcasting. In this case, the court held that NetEase has regarded webcasting market as a potential market, and fair use should only be limited to the field that are unable to generate lucrative profits to copyright owners. Thus, game webcasting is not a fair use because webcasting is proven to bring large economic benefits, but this view can be challenged based on following arguments. First, although game owner has legitimate expectation to broaden the scope of their copyrighted works due to advancement of technology, giving too much exclusive rights will lead to market monopoly. For example, game copyright holder may use his other resources to establish a prominent position in the webcasting market, causing monopoly and detrimental to market competition. We noticed that NetEase supports its own platform NetEase and Su Huado for Fantasy Westward Journey 2 picture copyright infringement. The game has its own traditional market of games, relevant products, and derivative works. Some game developers didn't expect the new emerging market and cannot explore the new market. According to utilitarianism theory, in the premise of assuring creation costs, appropriate economic profits is enough for future creation. It is neither necessary nor possible to explicitly define all interests in intellectual products and internalizing them into licensing interests. Actually, this is an issue of policy selection, since NetEase can also argue that although the industrial interests related to game webcasting are important, we cannot deny the game copyright owners exclusive rights. Even industry is based on infringing other copyrights, the industry of that industry are not worth protecting. According to natural rights theory, the webcasting of game originates from the game itself, so it is justified that game developers can gain appropriate share of benefits. Back to this case, Huado can defend the fair use should have grounds to avoid potential market monopoly. NetEase economic gains in the current market are enough, and the extra profits from webcasting market is available rather than necessary. And if all webcasters need to ask for permission and pay relevant fees before game webcasting, we render excessive incentives. In essence, the end of copyright system is to leave leeway to enrich public creating environments and promote social welfare, which internalizes the interests of works into the interests of private licensing in the form of property rights. To sum up, whether the game webcasting constitutes fair use is still an open question, as the developing level of webcasting industry and the legal theories adopted differ from countries. So how to balance interests between game developers and streamers in the context of Chinese legislation and industrial development?
Hi everyone, I'm Wang Rongwen. In this part, I will analyze these two texts from a comparative perspective, then make a conclusion in the context of Chinese copyright law. First of all, what is the disadvantage of the three-step test? The test derived from Berne Convention is a legislative standard for member countries to consider instead of the regulation that courts are deemed to apply. Also, the provision is too abstract, it lacks further interpretation and analyzing methods. This is the reason why Chinese judges refer to four-step test while applying three-step test. Then there are also defects in applying four-step tests. The transformative examination is too subjective, and there is no clear and universal guidelines in applying these four factors. That may be the reason why judges in Huaduo case held negative to refer to the transformative views theory. Though the four-step tests are nurtured in the soil of America, and three-step tests is a legislative standard for all member countries, the underlying expectation is always the same, is to balance copyright owners' interests, users' interests, and the public's interests. In this sense, we might as well compare the specific steps of the two different tests and find some coherence and connection. By comparison, we can find that the fourth factor in the four-step test could be applied to explain the second step, and the third step could be further explained by analyzing these three factors. Then we can analyze this question by applying four factors to explain three-step test. On the basis of Copyright Law Article 22 and the implementation of Copyright Law Article 21. As is not disputable in the first step, let's directly jump to the second step. The key word normal here points out a most controversial dispute, whether the potential market of game include webcasting game. It has been critically analyzed in the part 5, but if we discuss it in the context of Chinese copyright law, because Chinese copyright law structure originates from civil law, the policy choice may be inclined to natural right theory, admitting that webcasting market is encompassed in potential market of a game. Accordingly, unauthorized use of game screen in webcasting has a large possibility to impair normal exploitation of the original work. Now in China, the esports industry has established a completed chain of esports organization which require the game developers authorization in the very beginning. This industrial practice somehow supports the above opinion. Also, the type of game is also important in calculating the effect of markets, as the market of non-competitive games may be impaired more possibly and to a larger degree. The first step here is less controversial. The purpose of use is transformative to a degree. The nature of the game leaves little leeway for fair use, and the fourth factor depends highly on the type of the work. We could find that referring to four factors makes it more enforceable to further initiate the second and third step. Finally, we could conclude that although the explanation of law is a problem of policy choice, the purpose of fair use is always to balance the interest between the owners and the users. In the context of Chinese copyright law, four factors in four-step test could be used to further explain three-step tests. Webcasting is not in the exhaustive list of fair use, and the results of second and third step still depend on the type of the game. In conclusion, whether webcasting constitute fair use is a case-by-case analysis. Thank you for listening. Next, let's start question and answer session. Thank you.